Can Barack Obama run for presidency in Kenya? No, Barack Obama cannot be nominated or be elected as president of Kenya until and unless either he renounces his U.S. citizenship and applies for Kenyan citizenship, or Kenya amends its constitution. Article 137 of the Kenyan Constitution states: 1. A person qualifies for nomination as a presidential candidate if the person A. is a citizen by birth, B. is qualified to stand for election as a member of parliament, C. is nominated by a political party, or as an independent candidate, and D. is nominated by not fewer than 2,000 voters from each of a majority of the counties. 2. A person is not qualified for nomination as a presidential candidate if the person A. owes allegiance to a foreign state, or B. is a public officer, or is acting in any state or other public office. 3. Clause 2. B. shall not apply to A. the President, B. the Deputy President, or C. a Member of Parliament. Barack Obama, at the time of his birth, was not a Kenyan citizen. This is because at the time Barack Obama was born, Kenya was not a country. Barack Obama was born on August 4, 1961. Kenya did not become an independent country until June 1, 1963. Obama was born an overseas subject of the United Kingdom because at the time of his birth his father was an overseas subject of the United Kingdom, and the UK has long applied the rule that the children of overseas subjects are themselves overseas subjects, no matter where born. He, like all others who were overseas subjects of the United Kingdom arising from Kenya, automatically became a citizen of Kenya on December 12, 1963. However, his Kenyan citizenship was revoked on his 23rd birthday, August 4, 1984, because the then extant constitution required all Kenyan citizens who held another nationality to denounce that nationality prior to their 23rd birthday or lose Kenyan citizenship. Since Obama did not renounce his U.S. citizenship prior to his 23rd birthday, he ceased to be a Kenyan citizen on August 4, 1984. The current Kenyan constitution, adopted in 2010, removed the prohibition on dual citizenship but did not retroactively restore as a matter of law the citizenship of those who lost it under the old constitution. Rather, such individuals are automatically considered citizens by birth, and may apply for citizenship. Until they do, however, they will not be considered to have Kenyan nationality. Thus, under the current constitution, Obama would be considered a citizen by birth of Kenya, but is not actually a Kenyan national until and unless he applies for citizenship, which he has not as far as anyone is aware. The reason Obama cannot be nominated, or elected, as president of Kenya is because he owes allegiance to a foreign state, and is thus disqualified under Section 2 of Article 137. While Kenya allows dual citizenship generally, its constitution does not allow the president, or any nominee for president, to hold any nationality other than Kenyan. Obama can cure this defect, if he so wishes, by renouncing his U.S. citizenship and applying for Kenyan citizenship. Obama Sr. was without a doubt in 1961 a citizen of the United Kingdom and Colonies, and was himself born in Kenya. It is possible that Obama Jr. did not acquire either of the two statuses cited because he had acquired U.S. citizenship at birth. This might be the case, as the Bancroft Treaty between the U.S. and the UK was still nominally in force in 1961, as the U.S. did not formally withdraw from that treaty until 1980. While the Supreme Court strongly suggested that the US-UK Bancroft Treaty was ultra vires as early as 1964, for this purpose the status of the treaty under U.S. law is irrelevant. What matters is what the status of the treaty under UK law was. I don't have any good information as to whether the UK, in 1961, would have extended either citizenship in the United Kingdom and Colonies or British protected person status to an individual who was born in the US to a father having either of those statuses. However, I am fairly certain that Obama Jr. was, at the very least, a British protected person, even if he was not a citizen of the United Kingdom and Colonies at birth. The first thing he would have to do would be to reclaim the Kenyan citizenship that he presumably gave up at age 23, assuming that it is recognized that from birth he was a de facto Kenyan citizen by virtue of the fact that his father was Kenyan, and that he gave up his right to this at age 23 by never formally claiming his father's citizenship. He could then claim that he was a Kenyan by birth. The next thing he would have to do would be to renounce his U.S. citizenship, preferably soon after the end of his term. By doing so, he would thereby relinquish his allegiance to the U.S. Thereafter, all he would have to do would be to blink and every political party in Kenya would offer him nomination to the presidency. Or, he could run as an independent. He would win with overwhelming majority in every province of the republic. But then again, wait. Why would President Obama want to give up the stature and comforts of a former U.S. president and become president of Kenya? He's denied the country enough times, thanks to Tea Party witch hunting. I think this renders the question invalid.